So a couple of years ago, we decided to try to change the format of the symposium a little bit because as fabulous as the panelists that you'll see are and as great as those conversations are, we wanted to sort of give you guys a change of pace, and panels aren't always the best ways to communicate ideas. When we originally started the symposium, we sort of wanted to be focused on innovation and sort of the TED Talk of criminal justice was kind of the way we thought about this. And so we thought, well, what if we actually did use, and I don't want to, this is a law school, I don't want to give a trademark or copyright violation, but TED-esque talks that would allow people with really innovative things to say, to talk about their proposals in, a 20 or 25 minute conversation. So we started it last year. We called it our Profiles of Innovation, and it got a great response. And so we have two of those this year that we will be doing today. The first one, and I think, how many times, Rachel, have we said your name so far in this? Like 9, 10. And the reason that everybody says wonderful things about Rachel and points out, her role in doing things is that she's the sort of person that, hypothetically, if you were new to academia and were starting a criminal justice reform center and you really didn't have any idea what the hell you were doing, you might go to Rachel and say, please God, help me. And she would be empathetic and calm and supportive and insightful and generous with her time. And so we tried to have Rachel down to our very first symposium. She was too busy. Then we tried to get her down every other year since. I think the most dramatic reason she couldn't come was that there was a train derailment. So circumstances have conspired, but with persistence and perseverance, we've got her back, and we couldn't be happier about it. So Rachel is the Vice Dean and Siegel Family Professor of Regulatory Law and Policy at the New York University Law School. She's also the faculty director of the Center on the Administration of Criminal Law, which is a center that does really terrific work and one that we have actively stolen from and tried to imitate as much as we could. And as you'll see, she's a terrific presenter. She's the winner of the Podell Distinguished Teaching Award. In case you're wondering how smart she is, she's a Phi Beta Kappa at Northwestern and was on the Harvard Law Review at Harvard Law School, so let's put that to bed right away. She's smarter than me, she's smarter than you, she's smarter than everybody else in the room. She's consulted with the U.S. Sentencing Commission, and she's on the advisory panel for the District Attorney of New York's Conviction Integrity Unit. She's written a tremendous book called Prisoners of Politics: Breaking the Cycles of Mass Incarceration, where she, and I'm not gonna go into what she says. I'm gonna let her say it because she'll say it better than I would anyway. So please join me in welcoming Rachel Barkow.
Make sure you all can hear me okay. Thank you so much for having me this morning. I'm very grateful to be here, and the opening emphasis on data and evidence and facts as opposed to stories is my rallying cry. So I'm very happy to be able to talk to you about that. But I probably am here more in the capacity of a downer, because although Mark highlighted all the great things that have been done, he did say we're just nibbling around the edges. And I want to caution everyone that we're going to continue to just do that, to just nibble around the edges of criminal justice reform, unless we start fundamentally changing institutions, as opposed to just going around looking for low-hanging fruit of what could be reformed and changed. And that's the main point of my book as well, is that we need some bigger institutional fixes in order to get some of those bigger pushes and bigger changes. And I think there's a path forward for doing that I want to talk about with you this morning. But I think it's important to emphasize that. Now, when you look at criminal justice policies in America, I think Mark did a great job talking about their moral and constitutional and fiscal failures. The other thing I want to emphasize is they're terrible at making us safer. So in addition to all the tragedy and discriminatory outcomes they create, they also fail to achieve a kind of main goal that I think if you ask the public what they really wanted from criminal justice, which would be, we would like to be safer as a result of that. We would like to have less crime. So how is it that we end up with policies that are bad on every single one of these measures? Bad for public safety, constitutionally suspect in some ways, fiscally irresponsible, morally disturbing. And the argument I want to put forward to you is it's the politics behind how we make criminal justice policy in America. There's an expression in law schools that bad facts make bad law. You have bad facts, you get a case, the judges kind of go in a weird direction as a result of that. That's criminal justice policy in America writ large. Bad facts make bad law, and we have countless examples of that kind of dynamic operating in the political sphere, where some politician will just point out some individual case, some person that would benefit from a fundamental reform change that is particularly unsympathetic, and that will kill the entire law. No matter how much you might want to talk about data or facts or a rational approach to this. And I can give you a million examples, but I wasn't given enough time to do that. So instead, yeah, right, that's where I want to take the extra time. But I would like to give you a few of these examples of things that we do in criminal law that are counterproductive when it comes to public safety, but that we only get because of this weird political process and the way that we do things here. So one example would be, well, how do we treat sex offenders in America? Now that's a term you might think, okay, who are you picturing when you're thinking about sex offenders? You're probably thinking of the worst possible examples of sex offenses, a rape case, a child molestation case. I bet not very many of you are thinking about people who urinate in public because they had a few too many to drink, they couldn't quite make it to the bathroom, but that'll put you on a sex offender registry in at least 5 states. How about, I'm sorry, that's 13 states. If you visit a prostitute, that'll get you on the registry in 5. How about if you're teenagers and you send pictures of each other in a state of undress? Now you're a sex offender in 29 states. That's not just true of how we label sex offenders. And by the way, when we do that, we set our punishments and our consequences with the violent rapist in mind, not with thinking about all these other people that find themselves in the category. We do the same thing when it comes to drug offenders. They're sentenced based on the amount of quantity of drugs in their conspiracy. And so whether you are the kingpin of your conspiracy or you're a low-level mule or courier, you're all going to be held responsible for that quantity of drugs, and you're all going to be basically treated as if you were the kingpin. We do the same thing with 3 strikes laws, recidivist laws of various kinds. There's lots of examples of these. And their hallmark, though, is to think about the worst offender in a category and then make sure that the sentence and the consequences attaches to that kind of worst case scenario. And I think there's a thinking behind it that goes something along the lines of, well, so what? Longer sentences make us safer anyway. Longer sentences are better. You see a lot if you comment in social media about criminal justice policy. Well, do the crime, do the time. Then they shouldn't have committed the crime in the first place. And you see that not just in, I will say, social media, but actually at meetings with the government. So is that right? Is it right that we are setting our criminal punishments fairly proportionately to what people do? And do we get that kind of public safety bang from longer sentences, longer terms of confinement? What does that look like? And here I think it's really important to emphasize that we often are worse off when we give people longer sentences and when we confine them. And this is true whether we're talking about pretrial, and there's been great work here at Penn, among other places, looking at when you detain somebody pretrial. I think there's an assumption in the popular media, oh, that's a good thing, because then you don't hear the story of the person who's out on bail that commits some violent offense. What you don't see a media account of is detaining people pretrial actually creates a risk of future crime. We're talking about people who are living at the margins of society, and so even a few days detention, and remember, they haven't been convicted of anything yet, but even a few days of detention could mean they're gonna lose their housing, their job, their childcare arrangements, often the custody of their children. It is one of these kinds of things that can create just a spiral of decline in somebody's life. So it actually really shouldn't surprise us, the data that's been found, that there's an increased risk of recidivism holding constant what crime they committed and their criminal record. Just detaining them increases the risk of crime. And that's true when we look at people who've been convicted as well, and we look at, well, what if we give longer sentences to people? Surely we get that, maybe that deters them from committing crimes, or we're incapacitating them from committing crimes while they're detained. So one, on the deterrence point, it's really important to note that longer sentences don't have a huge effect on the calculus of most would-be criminal people engaging in criminal activity. They're really focused on whether they're going to get caught. And so sentence length really isn't having much of an impact there. And when we think about whether or not it's having that kind of deterrence effect, there's an interesting study out of Texas that found for every additional year that somebody served incarcerated, it created an increased recidivism risk of 4 to 7%. Okay, so if you think about why that might be, most people come out of prisons and jails in this country. 95% of people will come back out and rejoin us in our communities. And the longer you stay incarcerated, the harder it is to do that. You are that much further away from whatever technological developments have taken place. Your social ties with loved ones have been fractured and sometimes ended. It may be very expensive to keep in contact with them because of prison phone call fees or visitation fees, or you're far away. The conditions in the facility in which you've been held are probably poor, and there's probably very little programming being offered. So you're getting all these negative consequences. And although, yes, there is some incapacitative benefit to putting somebody in a prison, the assumption is that they would have continued to commit more crimes. But the other thing we know is most people age out of their criminal activity over time. So we're kind of using this big, expensive means of addressing public safety. We're not taking into account the costs that it brings on the other end. And so as a result, we're overusing it. And I like Mark's point. This is just a big failure of a government program. If this were anything else, I think people would say, how could we keep doing this again and again? And it's expensive and it's causing all this misery. So when we look at whether it's pretrial detention policies, incarceration policies, collateral consequences, which Mark alluded to, the thousands of them, these include things like people need housing when they're released from prison. We have 1/3 of the people who are released from prison are homeless within 6 months of their release. And yet we have strict housing bans on allowing people who have convictions to live in public housing, particularly if there's any engagement with drug trafficking. So anyone in your household sells or uses drugs, the whole household is evicted. Similarly, we have all kinds of other bans on people from obtaining welfare benefits. We often have states take away your driver's license if you have a conviction, particularly for drug felonies. Right now, we have 18 states who account for about 48% of the country's population has that ban in place where you lose your driver's license with a drug conviction. In most of those places, that means you're not going to be able to get a job. There's just not sufficient public transportation where these places are for people to be able to then go get a job and then support themselves and get housing. And so we're setting people up to fail. These are really bad public safety if that's what our goal is. And I've got lots and lots and lots more examples like this, but I've just given you a flavor for some of these things. So how does this happen? How do we end up with these policies that they're very punitive and they may feel, they may satiate some kind of desire that people have to just punish people, to be angry at people. But if our goal was to help people commit fewer crimes, to help people re-enter society, these policies are absolutely awful. So how do we get them? Well, we get them because of a political process that really does focus on the worst cases. So the people that the public and politicians have in mind when they're debating this kind of stuff are the worst kind of offender in a category, right? The kind you see on the evening news, which will, for those who still watch it, they still have a pretty steady drumbeat of criminal justice stories on a local newscast. And people who watch the news are more punitive than people who do not. There's studies about that too. But they're profiling, the most violent, most heinous crimes they can possibly find. And so when the debate is over various policies, that's kind of who comes to mind and who people are thinking of. And they're not thinking of this vast sea of 2.2 million people who end up incarcerated who've committed a variety of offenses, but don't look anything like the kind of prototype they have in their mind. But our political process doesn't do a very good job kind of making that clear. The other thing that we have to think about through our political process is we have stakeholders who are going to fight against criminal justice reform. So Mark had alluded to various things that didn't quite go as far as would have been ideal. And if you were to look closer at who was opposing many of those reforms, it was often the Department of Justice, for example. So just to pick up on the forensic policy issue, those recommendations were both fought against in the Obama administration and then just made worse in the Trump administration, but both of them opposed the idea of creating this independent forensic commission. Ditto for mens rea reform in criminal laws. That was both administrations. We often see around the country prosecutors, district attorneys associations are leading the way in opposing reforms that people are suggesting, whether it's mandatory minimum reform changes, changing policies for discovery practices, bail reform, and pretrial detention reform. It's often a district attorneys association or various DAs who say no. And I think it's important to pay attention to that, because that's a vested stakeholder in maintaining things as they are. And if we want to change the politics in America, we really have to think about how we're going to deal with that and how we're going to address it. So there's a quote from a district attorney in Lancaster, Pennsylvania that I like, because I think it actually is a pretty good indication of where they're coming at with this. So one is they want to make their jobs easier. But he also, when he was advocating for longer sentences for people who sell heroin, he said, I'm quoting him now, "I'm pissed off and we need to do something about it." And that was it. That was the whole thing. It wasn't, I did the study about what we could do to address the sale of heroin. He's just pissed off, and he wants to do something about it. And I think he has a good sense that his voters are pissed off, and they want to do something about it. And so that's how we make policy in the United States when it comes to criminal justice. And it's actually no more sophisticated than that. Someone's angry about something, and then there's some kind of reflexive passage of a law, and no one ever then studies it to see, was that the right thing to do? Should we have done better? There's no consideration of any of this. So I teach administrative law as well as criminal law, and this is like the craziest thing in the world to me, because we don't deal with any other area of health and safety this way. This is just not how we do things, thankfully. We don't just kind of put it up to public referenda, hey, should we keep flying planes? Because think about if we did, what would happen? As soon as there's a crash, if we approach that issue like we approach criminal law, we would stop flying all planes, just like we stop all parole or all furlough programs or all retroactive sentencing relief when there's just one bad case that people talk about. So why doesn't that happen in those other spaces? Because we have in place people who look at data and try to figure out on net, are we better off keeping this thing we have? How can we improve it? But not just reflexively saying, well, we got to get rid of everything because there was one bad story and it's time to let it go. Now, you would think in criminal law we'd be really sensitive to making that rational because we're imposing such great consequences on people, but unfortunately we don't. It's an area where our kind of chief regulators tend to be prosecutors. And as I mentioned, those prosecutors themselves aren't looking at a whole lot of data and evidence and coming up with their policies. Instead, they're really thinking about what makes their own job easier. So even if it's true, which it is, that mandatory sentencing laws are bad public policy, they create racial disparities, they do not end them, they're bad for public safety, they do not decrease crime. What they do, though, is really help prosecutors get people to plead guilty. And so they're a very powerful tool, and prosecutors have admitted this themselves. The National Association of Assistant U.S. Attorneys stated in a letter that mandatory minimum sentences are an indispensable tool. They are the leverage, the hammer comes from those penalties. All right. I get that. That makes their job easier, and I believe they're acting in good faith, thinking that when they do their job, they're doing the right thing. But this is not an agency of government that's investigating to make sure they're maximizing public safety using evidence or data or studying anything they're doing it. It's all gut. It's all their gut instinct of what they think works, what they think works best. And so there's no real focused consideration of trade-offs of what they're doing. They're not held accountable for it. They're not held accountable for their the long-term consequences of their decisions. That's true of our nation's prisons as well. We don't ask, hey, after someone goes through your prison, how are they doing afterwards? There is no accountability for that. So when corrections officers are making decisions or wardens are making decisions, they may think, oh yeah, well, I'll put somebody in solitary confinement because it makes it easier for me to have that in my toolkit to punish people internally to this facility. And they're not thinking about the fact that anyone who goes through that, when they come back out of that facility, will have mental health issues associated with that for the duration as a result of what they went through. So we, the public, as well as the person directly affected, will all bear those costs, even though professionally it might have made sense for the person who's doing it. So we have that all over criminal justice policy. in America. And so it's like a whole book length's worth, which I'm trying to summarize for you. So, okay, so I want to end with a positive set of things. What should we do about it? So I would say, in addition to continuing to pursue all the kinds of things that Mark talked about, which I think are great. I think, I agree with him. We shouldn't necessarily call things modest or small, but just relative to the scope of the problem. If you think of our problem as having historically high records of incarceration and to be an anomaly in the rest of the world, which we are, the problem is huge. And so if we wanted to have reforms that are comparable to the nature of the problem, then I think there's kind of 3 areas that I would like us to focus on. So the first involves prosecutors, which Mark mentioned, and I'm going to just reiterate and agree with. We really have to focus on checks on their power and authority, because they are kind of the key gatekeepers in this system, and we really don't have a lot of checks in place on how they operate. So there are things we can do to put some checks in place. We could eliminate mandatory minimums, and should, because that will allow judges to exercise a check on what they do. It is, as Mark put it, ridiculous to sentence somebody for a long term of confinement and never rethink that again. Because what we're doing when we do that is we're just deferring to the prosecutor's assessment on the day of sentencing of what they're recommending. Oftentimes the judge has no discretion, and we're not going to revisit it again, even when that sentence is 30 years, 40 years. So where else in society would we do that? Would we say, oh, let's just make a decision at time 1 and never look at that again for 30, 40 years. We'll check back in and see how it went. No, normally we would think we would want to kind of go in, make sure how are things going? Have we learned something new that we want to revise? So we should have second looks of sentences. We should have parole. We should have robust clemency, where we assess how people are doing. And when we learn new things about crimes, we alter our policies as a result, and we make retroactive changes to fix things that we got wrong. We should not make prison a free resource for prosecutors. So your local prosecutor can make unlimited free use of your state prison facilities. So if you think of your own life when someone tells you something is free, whether or not you exercise a lot of self-discipline in deciding how much of it to use, I mean, you may be better people than I am, but I don't. So as soon as I hear something is free, like it's a free bucket, it's like, I'll just take a whole bunch. That's why at Halloween we have to put a sign up for the kids, please take 2 or 3 pieces, because, before they'd take the entire bucket, and I don't blame them. Prosecutors do that. They take the whole bucket of prison because they don't have to pay for it. And we really need to think about ways to create fiscal caps on the use of that so that they have to take and internalize some of those costs. We need better review processes in place for them when they misbehave, and we absolutely should think about changing the immunity doctrines associated with them. So we need to think about their leverage in plea bargaining as well. So these are also things Mark brought up. So I appreciate being able to kind of follow that, because he asked, how can it even be that you could punish somebody more if they exercise their 6th Amendment right to trial? Like, how could that be that we would have that? And he said, I'm not a con law professor. I don't understand how that could happen. Well, if you are a con law professor, and we have good ones here, you look at the cases where the Supreme Court has decided this, and the court essentially basically adopted a view of the jury trial right that is different from how it treats other constitutional rights and the conditions that it allows the government to place on those rights. In other contexts, the court does recognize it's an unconstitutional condition to force somebody to give up a right and make them in order to get some other kind of a benefit. But in the context of plea bargaining and the 6th Amendment right to a jury trial, the Supreme Court didn't do that. Similarly, those immunity doctrines, those aren't found in the text of any law. That wasn't enacted. The court created that stuff. They just made it up. They made up the immunity doctrines that we see. How are these sentences so long that are threatened when we have an 8th Amendment that bans cruel and unusual punishment? Because the Supreme Court just doesn't enforce it. They really don't like doing it. They don't want to be in the business of doing that. So that leads me to the second bucket of reforms that I want to emphasize, which is, if we're thinking big, and I think we should, we need to think about who is on the bench. Who are these people that are making this decision about constitutional rights, these decisions, and why do they keep getting slanted so much? Well, I think when you look, the puzzle starts to unravel in a way that I think becomes a little clearer. 43% of the federal judiciary is comprised of former prosecutors. So that's, like the biggest occupational group that's represented there, as compared to 10% of the people who have public defense backgrounds. So that's a really skewed ratio of who occupies the bench. And I know Cato has done great work updating those statistics to show it's even worse when you start to look at other people who had government side experience before they were appointed to the bench. And I think people who care about criminal justice reform should really care about that. Just as groups who care about labor rights or abortion rights or other rights that come up when judicial appointments open up, start to look and say, hey, is this justice going to be somebody who seems to get the issues that we're talking about? That should be true of criminal justice reform. Why don't we have people who do civil liberties work occupying our bench? You know, why is it that you could, when you think about Thurgood Marshall and his background, that we don't have other people like that being nominated to the courts today? And I would argue if we're really thinking big on criminal justice reform, we need to make the courts a top priority. So in addition to all those prosecutorial reforms, it's really important to think about how to change the courts. That'll be true of elected judges as well in states, although I have to tell you that's harder. But it should also be true for sure when we're thinking about the federal courts and who occupies them. The third bucket, and this is like lightning round, I'm going through fast, so I'm not defending these as much as I would like, but I'm happy to answer questions about them. The third thing is really thinking about that administrative law analogy that I brought up before. So in these other contexts, we have agencies of people who look at data to try to figure out what would be the best policy. When it comes to our air and our water and our workplaces, we have long ago recognized that we could look at studies and data to get things better than if we just trusted people's gut instincts. Criminal law has not yet entered that vanguard that has existed for 100 years now in other spaces, but it should, because it's not just a moral decision that we're making in these contexts. We are making public safety decisions, and that's often the animating decision that we're making is how can we maximize public safety with limited resources? So if we're going to do that, we should look at the best evidence that's out there. We shouldn't just pass a collateral consequence because somebody's pissed off and wants to do something about drug dealing, which essentially describes most of the collateral consequences that have been passed in this country. The 80s and 90s was just like a free-for-all where people were angry at drug dealers because of drug problems in neighborhoods, and I get the anger, but the policy response should be more considered than that. The policy response should really ask, is this going to deal with the underlying problem, or does this just make people feel better in the short term? Does it help get people elected because they can run an ad on it? And unfortunately, it's that, and it's not effective policy making. But if you had an agency structure in place, you could get better outcomes that aren't so immediately impacted by those political forces. So I want to just close by giving you two examples of, if you look at our incarceration rates in recent years, you'll find they are dropping at a very slow pace. And at the pace we're going, it'll take us 75 years to cut the population in half. But more significantly, that drop has been dominated by two developments. One is the Supreme Court decided a case called Brown versus Plata that required California to reduce its prison population by roughly 30,000 people. So California is a huge chunk of the overall drop in incarceration in America. And what prompted it? A Supreme Court decision finally enforcing one of the Eighth Amendment guarantees in terms of bad prison conditions there. The second big motivator for the drop in incarceration in the United States, not just the little stuff, but a big one, was the Sentencing Commission. And full disclosure, I was on it when we did it. But we reduced all federal drug sentences in the United States. And we made that change retroactive. And so that enabled people to go before a judge and ask to get resentenced. And more than 30,000 people got those reductions and got out of prison on average about a little less than 2 years earlier. So when you look at the federal prison population and its decline, that's what did it. How did that happen? Because it was an agency in Washington looking at data and recidivism rates. We knew we could do it and it wouldn't increase recidivism because there had been another drug reduction for people sentenced to crack earlier. And a bipartisan group of 7 people, Republicans and Democrats alike, could unanimously say, oh yeah, that's a no-brainer. We should do that. Do I think you could get 7 members of Congress to do that? I do not. Because I think the politics just make it too hard. So the idea is to create models and spaces that allow us to do that. And I will close there. I don't know if we have time for questions or is it?
Yeah, we've got a couple minutes if you want to take a question or two. Yeah, I think we do have a microphone that we can bring you so that we'll
See
show
that.
the fidelity of the report.
Okay.
Hello, can you hear me?
Yes.
I wrote my question down, and I just want to make sure if I can get your thoughts on it, and if you agree in what you think about it. And the question is, do you think that the adversarial system in and of itself produces a us versus them perspective that allows for a protectionist viewpoint that creates mass incarceration? For example, the drugs with crack cocaine was heavily punished. However, when the drug epidemic with heroin occurred, there was a lot of outreach and deterrence. And I believe the one DA that you quoted mentioned he was pissed. Us versus them would be, if it's happening to someone else we don't care about, I can punish it to stop it from happening in my neighborhood. Versus heroin, if it's happening to someone that I align myself with, I want to really do outreach. If that's true, how do you begin to unpack that philosophy from a DA so you can make sure that philosophy is not a us versus them, but more of a perspective of more holistic and more concerned about the entire person? Does that make sense to you?
Yeah, no, thank you. So I guess one factual correction I would just make to the premise of the question, which is I actually think that there's just as much punitive furor attached to heroin and opioids as there has been for other drugs. There's also a simultaneous path where people are talking about things like treatment and dealing with it in other ways. But if you look at district attorneys' offices around the country, you will see they are throwing the book at people who have, for example, shared their opioids with a girlfriend or a boyfriend. They're being prosecuted for homicide. So we're seeing a lot of the same kinds of trends even with that drug that we had before. But I think your broader question about adversarialism is correct, that I think it's not really appropriate to ask prosecutors who are on one side of the V in a case to be our leading public policymakers for criminal justice. And whenever we have asked them to do it, you see time and time again, it's impossible for them to separate what would be their professional interest from the policy goals. So we all already talked about forensics. It's been true in clemency. You know, Alice Marie Johnson, who Mark had mentioned, the Obama Department of Justice said deny her. She was denied under the Obama administration. And you just might ask, how could that be? Well, because prosecutors review those cases. They recommended deny in almost all of the cases. And I think that's kind of going to be a reflexive thing. You know, similar when we're talking about corrections policies and reform. No one could get compassionate release from the Department of Justice, no matter how ill they were, because the answer has always just been no. In fact, our retroactive adjustment of the drug sentencing, again, the Obama administration opposed giving that to everyone. They did not want us to do that. They wanted us to categorically bar certain groups of people from getting any retroactive relief, even though you had to go before a judge, so no one was going to get it automatically. They said, no, it shouldn't go to anyone with significant criminal history, who'd had any violence in their background, who had obstruction of justice counts. They had a whole group of people that shouldn't be able to get it. And I think it's because of what you're talking about, which is there is this kind of adversarial mentality that makes them ill-suited to make public policy choices. So I think both they should be out of the policy-making space, and at the same time, within the sphere in which they work, we want to be really careful that we don't give them these kinds of leverage and tools that enable them to kind of be overbearing on defendants and their interests.